The notice was taped to the front door on a Monday morning in March. Dorothy Haas had lived in that house for 41 years. She raised two children there, buried a husband from the front porch, and paid every bill that came through the mail slot until the bills stopped making sense to her. The county sold it, not to settle a lawsuit, not after a foreclosure hearing where anyone fought for her. They sold it over $14,000 in unpaid property taxes while she was sitting in a memory care facility 60 miles away, unaware that anything had changed. What nobody knew was that her husband Earl had rented a storage unit in 1989 and paid the lease through a separate account for the rest of his life. Dorothy never mentioned it. She may not have remembered it, but the unit was still there, and the lock had never been touched. In 2020, in Delaware County, Pennsylvania, a 79-year-old woman with moderate dementia lost her home of 4 decades over an unpaid property tax debt of $14,000. This is her story, with details changed to protect her privacy. Dorothy Haas had moved to the memory care wing of Cedarbrook Sr., living in Lansdale, in late 2018, after her daughter Karen noticed she had been leaving the stove on overnight and couldn't reliably recall what month it was. The transition had been quiet and without drama. Dorothy packed one suitcase. She brought her reading glasses, a framed photograph of Earl taken at a lake in 1976, and a small ceramic dish that had sat beside the kitchen sink for as long as either of her children could remember. She did not ask about the house. She seemed, in those first weeks, to believe she was somewhere temporary. Earl Haas had died in February of 2017 after 44 years of marriage. He had been a machinist at a manufacturing plant in Derby for most of his working life, a man who kept paper records of everything and paid his bills in the first week of every month. He had handled the finances. Dorothy had handled everything else. After he died, Karen took over the bills for a while, then her brother Michael took over, and then there was a period, about 8 months, when neither of them was certain who was responsible for what. The property tax account slipped. By the time anyone noticed, the county had already initiated proceedings under Pennsylvania's real estate tax sale law, a mechanism that allowed municipalities to seize and auction properties with delinquent taxes after a statutory notice period. The notices had been mailed to the house on Birchwood Lane. Dorothy was not there to receive them. Karen had changed the forwarding address for Dorothy's personal mail to the facility, but not for property-related county correspondence. The envelopes arrived, sat in a pile on the kitchen counter that nobody was checking, and eventually the deadline passed. In September of 2020, during the first autumn of the COVID pandemic, Delaware County listed the property at public auction. A buyer named Gerald Stalk purchased it for $78,000. The county retained the $14,000 owed plus fees. The remaining equity, approximately $59,000, in a house that had been appraised at $247,000, was not returned to Dorothy or her estate. Under the statute as written, the county was entitled to keep it. Karen found out in November when she tried to access the house to retrieve Dorothy's winter clothes. The lockbox had been changed. A notice of new ownership was posted in the window. She stood on the porch of the house where she had grown up and read the notice twice before she understood what it said. She drove back to the facility and sat in her car in the parking lot for a long time. When she finally went inside, Dorothy was at a table by the window doing a puzzle, a photograph of the Swiss Alps broken into 500 pieces. She looked up when Karen walked in and smiled, then looked back at the puzzle. Karen sat with her for 2 hours and said nothing about the house. That evening, cleaning out a box of Earl's papers she had kept in her spare bedroom, Karen found a receipt. It was dated November 3, 1989, from a self-storage facility called Reliable Storage on Route 420 in Essington. The monthly rental rate was listed as $31. Clipped to it was a handwritten note in Earl's careful, slanted print. Unit 114. Contents: household records, financial documents, personal items. Do not discard. Karen held the receipt under the lamp for a long time. She did not know what was in the unit. She did not know if Earl had kept paying for it after he wrote that note, or for how long. She did not know if the facility still existed. She put the receipt in her coat pocket and drove home, but she didn't sleep that much that night. The drive to Essington took 34 minutes on a Wednesday morning in early December. Karen left before 7, before the morning commute thickened on Route 291, and she drove with the heat on high and the radio off. The sky was flat and white, the kind of December sky that gives no indication of what it intends to do. A light freezing rain had fallen overnight, and the road shoulders were still dark with it. Reliable storage had not closed. It sat on the west side of Route 420, between a tire shop and a vacant lot. A long, low building of corrugated metal, painted pale yellow, with a chain-link fence along the perimeter and a small office structure at the front with a neon open sign in the window. The sign was on. Karen pulled into the lot at 7:22 a.m. and sat for a moment looking at the building. There were perhaps 40 units visible from the lot. A rusted unit number placard near the far end read 110 to 120. The woman in the office was named Pat. She had worked there since 2004, she said, without being asked. Karen explained the situation. Her father had rented a unit in 1989. Her father had died in 2017. She had found the original receipt. She wasn't certain if the account was still active. Pat typed Earl's last name into the computer and waited. Then she said, the account was paid through automatic bank draft. The account had not been canceled. The unit had not been accessed. She checked the log. Since March of 2012, when an entry showed Earl Haas had visited and updated the combination lock. The monthly rate had increased over the years to $68. The account was current. Pat handed Karen a clipboard with an access authorization form. Karen signed it with Earl's name in the secondary holder field, which Pat accepted on the basis of the death certificate Karen had thought to bring. Then Pat gave her a slip of paper with a 4-digit code for the outer gate and told her Unit 114 was in the second row, third from the end. The cold inside the storage corridor was different from the cold outside. Stiller, older. It smelled of rubber and dust and something faintly sweet that Karen couldn't identify. Her footsteps on the concrete echoed off the metal walls. The doors of the units were heavy orange roll-up panels, each with a numbered placard and a small padlock hasp. Unit 114 was identical to the others, except that the padlock was a combination type, black and heavy, with a 4-digit dial. The combination was the same 4 digits Earl had used for everything. Dorothy's birthday, reversed. The door rolled up with a sound like a slow exhale. The unit was approximately 10 feet by 12. It was clean, not pristine, but organized in a way that was immediately recognizable to Karen as her father's organizing. Cardboard banker's boxes were stacked along the left wall, labeled in Earl's handwriting by year, starting with 1979 and running through 2016. On the right wall, a metal shelving unit held a row of accordion folders, a portable fireproof document safe about the size of a shoebox, and a green plastic bin sealed with tape that Karen did not open that day. In the center of the floor, a single folding table held 3 items: a sealed envelope with Karen or Michael written on the front, a small framed photograph, the same lake, the same summer, a different angle, and a 1989 Farmer's Almanac with a rubber band around it. Karen picked up the envelope. It was sealed with packing tape, the kind her father used for everything. She did not open it yet. She stood holding it in the cold of the unit and looked at the rows of boxes and understood, in a way she hadn't anticipated, how much of her father's life was in this room. She opened the fireproof safe first. Using a key, she found tape to the back of the almanac. Inside were 6 documents in plastic sleeves. The first was the deed to the Birchwood Lane property, recorded in 1981. The second was a life insurance policy issued in 1988, with Dorothy listed as sole beneficiary. Face value $110,000. Karen had not known this policy existed. The third document was a handwritten ledger, 14 pages, recording every payment Earl had made on a second savings account at a credit union in Springfield. The account had been opened in 1994. The balance on the last entry, dated January 2017, 5 weeks before Earl died, was $91,400. Karen sat down on the cold concrete floor of Unit 114 and read the ledger from the first entry to the last. It had taken Earl 23 years to save that money, $12 at a time some months, $200 at a time in others, logged in his careful hand with the date and the running balance. At the top of the first page, he had written a single sentence: "For Dorothy, so she is never without." She opened the envelope after that. It was a letter, 3 pages, written by hand, addressed to both of them. Earl had written it in 2016, when he knew he was sick. It explained the storage unit, the savings account, the insurance policy. It gave the credit union account number, the insurance policy number, the name of the attorney he had used to draft a will that, Karen now realized, had never been located after his death. It also named the attorney, a woman in Media, Pennsylvania, named Sylvia Cho. Karen called Sylvia Cho's office from the parking lot of Reliable Storage, standing in the freezing rain with the letter in her hand. The office was open. She was put on hold for 4 minutes. Then Sylvia Cho picked up the line and said she had been wondering when someone would call. Sylvia Cho had drafted Earl's will in October of 2016 and had been holding the original, along with a sealed letter of instruction, in her client files ever since. She had sent 2 written notices to the Birchwood Lane address after Earl's death, once in April of 2017 and once in January of 2018. Neither had been responded to. She had not pursued further contact, she explained, because the instructions were to wait until contacted. Earl had been specific about that. The will was straightforward. The Birchwood Lane property was left entirely to Dorothy. The credit union savings account, which Karen had not known existed and which still held $91,400 plus 11 years of modest interest, was left to Dorothy. The insurance policy payout was left to Dorothy. Earl had written the will with one purpose: to ensure his wife could not be made destitute, regardless of what happened to him or to their children's attentiveness. Sylvia Cho met with Karen at her office in Media 2 days later. The will had never been probated. The insurance policy had lapsed without a claim being filed. The credit union account was still open, still accruing, still waiting. None of these facts changed what had already happened to the house. But together, Sylvia explained, they established something critical. Dorothy Haas had not been a woman without resources. She had been a woman whose resources were unknown to the county, unknown to the buyer, and, because of the failures in the months after Earl's death, unknown to her own children. The sale had proceeded as though she were destitute. She was not. The legal mechanism Sylvia cited was a doctrine recognized in Pennsylvania equity courts called unjust enrichment, a principle holding that a party cannot retain a benefit to which they are not legally entitled when that retention causes demonstrable harm to another. Applied to a tax sale, it required showing that the government or the buyer had received value far exceeding what the law permitted them to retain. Delaware County had collected $14,000 in back taxes and kept approximately $59,000 in surplus equity. The buyer had paid $78,000 for a property conservatively valued at $247,000. Sylvia filed a civil complaint in Delaware County Court of Common Pleas in January of 2021, naming both the county and Gerald Stalk as defendants. Stalk's attorney responded within 2 weeks. The letter was civil in tone and absolute in position. The sale had followed statutory procedure. The buyer had purchased in good faith, and the county had acted within its legal authority under the real estate tax sale law. The letter noted that Dorothy's incapacity at the time of the sale created no additional legal obligation on the county's part. Karen read that sentence 3 times. In March of 2021, Gerald Stalk listed the Birchwood Lane property for sale at $229,000. Karen found the listing on a real estate website on a Tuesday evening. She called Sylvia the next morning. Sylvia had already seen it. She filed an emergency motion for Ellis Pendens, a legal notice recorded against the property title that alerts any prospective buyer to active litigation. The effect was immediate. The listing was pulled within a week. Stock could not sell the property with a lice pendens attached without disclosing the lawsuit, and no buyer's lender would finance a purchase under those conditions. The confrontation came in April. Stock's attorney requested a meeting. It was held at a conference room in a law office in Wilmington, a neutral location chosen by Stock's side. Karen did not attend. Sylvia went alone. Stock and his attorney offered a settlement. They would pay Dorothy $22,000 and retain the property. Sylvia declined without counteroffer. She said the number was not serious and that she intended to proceed to trial. Stock's attorney asked what number would be serious. Sylvia said the number was the full appraised value of the property at the time of sale, less the legitimate tax debt and documented costs. She left the meeting after 11 minutes. By late 2021, the legal landscape had begun to shift. A case out of Minnesota, Tyler versus Hennepin County, was working its way through the federal courts on nearly identical facts. A county had seized and sold a home for a small tax debt and kept all surplus equity above the debt. The Eighth Circuit ruled against the homeowner. The case was appealed to the U.S. Supreme Court. Sylvia tracked it closely. She filed a motion to stay the Delaware County proceedings pending the Supreme Court's decision, arguing that the constitutional question in Tyler would determine the framework for Dorothy's case. The motion was granted. In May of 2023, the Supreme Court ruled unanimously in Tyler versus Hennepin County that the government's retention of surplus equity from a tax sale constituted an unconstitutional taking under the Fifth Amendment. The opinion was written by Chief Justice Roberts. It was 9 pages long. Sylvia read it the morning it was issued and called Karen before the end of the first paragraph. Delaware County did not wait for a second filing. Within 60 days of the Tyler ruling, the county's solicitor contacted Sylvia's office to discuss resolution. Stock, facing a now constitutionally compromised title and a legal environment that had shifted entirely against him, agreed to resell the property through a structured negotiation. He had paid $78,000. He had spent approximately $14,000 on carrying costs, repairs, and legal fees over 3 years. Sylvia's position was that Dorothy was owed the full surplus above the legitimate tax debt, approximately $59,000 from the county, plus compensatory damages reflective of the property's current value versus what Stock had paid. In November of 2023, the parties reached a settlement. The county paid Dorothy $59,400. Stock paid an additional $88,000. Dorothy's total recovery was $147,400. Karen drove to Cedarbrook that afternoon. Dorothy was at the window table again. The Swiss Alps puzzle had been finished and framed and hung on the wall beside the door. She was starting a new one, a covered bridge in Vermont, 1,000 pieces, still in the box. She looked up when Karen came in, and this time she said Karen's name clearly, without hesitation, which was not always how it went. Karen sat down beside her and they worked on the puzzle together for an hour. She didn't say anything about the settlement. There would be time for that. The settlement was finalized in the Delaware County Court of Common Pleas on November 19, 2023. The order confirmed the payment of $147,400 to Dorothy Haas, held in trust by Sylvia Cho, pending appointment of a legal guardian for Dorothy's financial affairs. Karen was appointed guardian in January of 2024. The Birchwood Lane property was not recovered. It remained with Stock, now with a clear title and a resolved litigation history. But Karen understood, and Sylvia had said plainly, that recovering the house itself had never been the realistic outcome. Dorothy did not know the house was gone. She had not mentioned it in 2 years. The credit union savings account that Earl had been building since 1994 had grown with interest to $96,200. The life insurance policy had lapsed, but Sylvia had filed a claim with the insurer arguing that the policyholder had lacked the capacity to manage the policy, and that the lapse should be voided under Pennsylvania's incapacity statute. The insurer settled that claim separately in March of 2024 for $74,000. Not the full face value, but more than half. Combined with the legal settlement, Dorothy's total accessible assets came to just over $317,000. Karen used a portion of those funds to move Dorothy to a private room at Cedarbrook, a room with a larger window and a small outdoor courtyard she could see from her chair. She bought Dorothy a better reading lamp. She framed Earl's letter, the 3-page letter from the storage unit, and hung it on the wall beside the photograph of the lake. Dorothy sometimes looked at it for a long time without saying anything. Once she touched Earl's signature at the bottom and said, "He was very careful about things." Karen said yes, he was. In the spring of 2024, Karen contacted a nonprofit in Delaware County called the Home Preservation Project, which provided free legal assistance to elderly homeowners facing tax delinquency. She made a donation of $15,000 in Earl's name. She also spent 2 afternoons with their staff explaining the procedural failures that had allowed her mother's situation to reach the point it did: the forwarding address gap, the probate oversight, the insurance policy that had been allowed to lapse, so they could build a checklist for families in similar transitions. The checklist was incorporated into the organization's intake process that fall. Sylvia Cho, who had taken the case on a contingency basis and collected her fee from the settlement, sent Karen a note afterward that said only, "Your father would have approved." Dorothy Haas did not know that a county had sold her home, or that the Supreme Court of the United States had ruled that what was done to her was unconstitutional, or that her husband had spent 23 years quietly ensuring she would never be without. She knew the photograph of the lake. She knew Karen's face when she walked in. She knew the covered bridge puzzle, which she finished in February, and which now hung beside the Swiss Alps on the wall by the door. On a Tuesday morning in March of 2024, 4 years to the month from the notice taped to the front door on Birchwood Lane, Karen brought Dorothy a slice of lemon cake from the bakery on the corner near the facility, the kind Dorothy had always made for birthdays. They sat at the window table and ate it together, and the courtyard outside was just beginning to show the first pale suggestion of crocuses coming up through the last of the cold ground. Dorothy looked at the courtyard for a while, and then looked at Karen and said, "It's going to be a nice spring." Karen said, "Yes, it is."